Bank AG and Sebastian Holdings are another partner.
Yes, Mr. Lane.
Good morning, my lord. I was on the fifth alleged error under the Beatrice topic, which is my last point on this topic. And this error is said to be by Mr Vik, that the judge rejected his evidence that he was advised to keep his distance from the trust and follow that advice. Now, the judge's reasons for rejecting that evidence are in her judgment at paragraphs 167 to 172. And Mr Vik's case on the issue is in his skeleton argument at 122 to 123. In fact, Mr Vik fails to identify any error in the judge's reasoning. And I have 5 points on this. First, Mr Vik says his case is supported by depositions given by his wife and daughter. The depositions I think we've looked at, they're in the supplemental third volume at tab 34 and tab 35. Mr Vik identifies no specific passage from the evidence which substantiates his position, and in fact nothing in the deposition evidence supports his argument, because they simply confirm Mr Vik's wife and daughter could not have managed the trust's affairs without Mr Vik's involvement. The second point is that Mr Vik says it was in the interests of the trust and Beatrice that Mr Vik should not be involved in managing or otherwise aware of their assets, and that's at paragraph 122 of his skeleton. Again, no evidence is cited in support of that bold proposition. It's also inconsistent with his position as the first protector and all the provisions in the trust deed granting him legal rights as settler. Third, he impugns the judge's finding that his evidence at the Part 71 hearing was inconsistent with his evidence at the committal hearing, but his own evidence was inconsistent. So he disclosed for the first time at the Part 71 hearing his resignation as protector. When asked why he'd resigned, he said that he had decided to retire, not that he was following advice to keep his distance from the trust. And that's at Supplemental 1, Tab 1, page 10, and it's at the transcript, pages 26 to 31. At the committal hearing, inconsistently, his explanation had changed. Now he said it was because Withers had advised him not to be involved with the trust. And that's in the core supplemental bundle, tab 6, page 47, and it's the transcript, pages 9 to 13. The fourth point is that Mr Vik attacks the judge's conclusion that if he'd been advised to distance himself, he would have appointed truly independent trustees with appropriate expertise. That was the judge's finding at paragraph 172. And the logic of the judge's approach is obvious, given that there were no trustees who could run the trust appropriately, if I can use that as shorthand. That's wholly inconsistent with the strategy of Mr Vik distancing himself from the trust. His remaining criticisms on the issue repeat other grounds concerning the judge's approach to credibility. That's in his paragraph 123 of his skeleton, and his points go nowhere. Similarly, his points on her conclusions on the understanding of his role as protector. Finally, he suggests that even if the judge's findings as to his knowledge of Beatrice and the trust stand, the judge had no basis to find that he knew what funds of SHI were held by Beatrice in August 2015. And that's wrong. Once it's accepted that he knew what the assets were in Beatrice, it follows that he knew which assets of SHI it held. And that's because he transferred SHI's assets into Beatrice in the first place. And that was my fifth point. So overall,
Can you show us where that question in the cross-examination was?
the question, my lord.
Do you know which assets of SHI are held by Beatrice?
I can check that. We'll find that. I assume it will be. Do you mean at the Part 71 hearing?
Well, the contempt that's found is that he didn't answer that question correctly, so he must have been asked that question.
Yes. So it's in the core supplemental bundle at tab 1.
Page 8, I think.
Page 8.
Yep. Page 62, line 1.
That's right. And I think we looked at that yesterday.
And is there any argument as to what that question means? Does it mean funds that it's still holding which derived from a transfer from SHI, or does it mean funds that it's holding for SHI, or funds that SHI has a claim to recover? What does it mean?
I think it was following the questioning of following the transfer, what funds of SHI is it still holding? If you look at the questioning that went before. So have you disposed of the monies held by Beatrice since then? No. Can you tell what assets Beatrice currently has? No. What funds of SHI is it still holding? You could have asked Mr Brocken.
Okay. What do you say it means?
I say it means what funds of SHI is it still holding from the ones you transferred?
Does it mean funds belonging to SHI or funds derived from SHI?
Funds belonging to SHI, funds of SHI.
You can't answer that question until you know whether SHI has a right to recover the funds, and that's a controversial question, isn't it?
I don't think so, my lord. He was. This is what I was saying yesterday. It's a Part 71 hearing. He is turning up as the person who's been found to have stripped SHI of its assets, and they were his monies that he says he's put into his savings company Beatrice and then transferred to a trust, and his case is inconsistent as to what he was doing for the 7 years he was the protector and what he knew, and there's a whole structure of questioning which is derived for him to come to the court and say this is what happened to those funds and what is there now. And those questions are clear. There are quite a series of open and closed questions. And his obligation, as I said, I think it's important to have in mind that it's not just simply for him to answer questions, as Mrs Justice Cockrell found. It's for him to come and provide information to the court about the assets.
My point's a slightly different one. If he's asked factual questions, he can be expected to answer factual questions to the best of his factual knowledge. But asking a question, what does Beatrice hold which really belongs to SHI, involves a legal conclusion that SHI has a legal right to recover the monies transferred in 2008 from SHI to Beatrice. Now that is no doubt your case, but it's a legal conclusion. It's not a factual piece of factual information.
But the Court of Appeal had found in 2014 that these were rightfully SHI's funds. So he is being asked questions on the basis of findings made.
Well, on Mr Vik's case, which is that he made, or SHI made, an outright gift of the funds, the answer is easy. It's none.
Yeah.
I mean, his case is that it's a gift, and therefore SHI doesn't have a right to recover anything, and therefore Beatrice, so far as he's concerned, is not holding any funds to which SHI has a right, and he knows that.
Yeah.
But it all depends what the question means, I suppose.
Well, I think the starting point is that the Court of Appeal had found that these are SHI's funds. And Mr Vik knows that because these were findings made that he didn't like, but you've seen, didn't challenge. I'm not saying there's an issue with estoppel, but he didn't challenge them. He knows that's the basis on which he's being asked to answer these questions. And he also has the credit line in operation whereby SHI is taking funds from Beatrice.
But a credit line is an ability to borrow. That doesn't make the funds yours.
Well, no documentation. I'm calling it the credit line because he's called it that. But there's no evidence of of anything other than SHI could get the funds from Beatrice as it wished. And it ended up with 25 million from Beatrice net, as it wished, with no evidence as
If
to
you'd
why.
wanted to ask him how much money could SHI take from Beatrice if it wanted to, that would be a different question, it seems to me, from what funds of SHI are in Beatrice.
Well,
And you may be right, as my lord says, you may well have understood the question as meaning what funds derived from SHI, which the Court of Appeal has held still belong to SHI.
Yeah.
Because if he'd understood the question to be, what do you accept belongs to SHI,
he would have said no.
he would have said, there's nothing, because it's all Beatrice's. But I don't think it's obvious just reading that question cold on the page, either what was meant or what he understood by it.
Well, my lord, there's 3 points to that. First, the question can't be read cold.
Well, I understand that.
It really can't, and Part 71 would be completely undermined if one was going to take that approach, and it's not the approach set out in the White Book. It would be a radical change to the rules. The whole idea is that the contemner is coming, the judgment officer of the judgment debtor is coming to court to give information, and that is in the context of everything that has gone before. Number 2, the question can't be read in isolation with respect, as your lordship is doing, and I said yesterday it came in 7 parts, this structure. It's not a cross-examination, so criticisms of is it very tight, this questioning, don't fly, and there's a contrast between the cross-examination you will have seen in the 4 days of Mr Vik when it was cross-examination. The nature of examination of Part 71 is investigative, and it was cumulative as the day was going on.
I'm not sure I understand that submission. What difference does it make whether it's characterised as a cross-examination or an examination?
Well,
you're entitled to ask questions.
I am, but I think there can be criticisms made of a cross-examiner that the question's leading, or that the question...
you can ask leading questions, you can ask open-ended questions, you can ask practically anything you like.
Or rolled, let me give a better example. People often complain about rolled-up questions for cross-examination, or that you ideally ask closed questions. These are, and criticisms can be made of it. A Part 71 hearing is not an opportunity to criticise the questioner's questioning. It's to gather information, and it's then for the court to assess whether the relevant individual honestly provided the information and the answers that he knew to the best of his ability.
It's not a question of criticising the question, it's simply whether the question is sufficiently clear that Mr Vik's clear answer to it is demonstrated to be untrue.
The third point is that Mr Vik hasn't complained.
Well, I was about to intervene and say that one thing he doesn't say is, I don't understand your question.
But also, this isn't a question about which complaint is made. The questions that he said that he didn't understand were
it's not a question about which complaint is made, but it is, as I understand it, it is one of his grounds of appeal that the judge didn't have the material to find that he was lying on this answer. And one needs to understand what this answer is saying in order to be sure that he was guilty of contempt in answering it wrongly, knowingly wrongly.
Well, I think it's clear that it's shorthand for which of SHI's funds that you transferred are still there.
Right.
I think that's clearly what it's shorthand for. I think that's how he understood it. I think that, my lord, he hasn't ever said he didn't understand the question.
Yep.
But the reason why that's significant is he didn't say it there. He had leading counsel representing him, not Mr Matthews, but and I think it was Stephen Cogby, King's Counsel, was representing him and did intervene at times, didn't intervene at that point. He's never said then, in the many challenges that have since been made, that he didn't understand that question. And it's not in a part of the grounds here that he didn't understand the question. So I think
it's only me who doesn't understand the question.
Well, it may be, my lord, it could have been put more tightly, but I hope you can see that Mr Vik is not the easiest witness to cross-examine, and one does try go around the houses with him sometimes.
Thank you.
So moving on then, please, to the Devon Park interest. Our submissions can be found in section E of our skeleton, paragraphs 134 to 187. And this is another example of asset stripping that Mr Vik lied about it at the Part 71 hearing. So just to ensure your lordships know what it is, it was a very valuable 23% interest which SHI held in a biotechnology fund called Devon Park. And the evidence suggested that it was worth over $44 million in December 2015. In August 2014, SHI assigned the Devon Park interest to a company called Universal for no consideration. Universal was a recently incorporated off-the-shelf Panamanian corporation, and it was only incorporated in Panama on the 23rd of September 2013. Our case...
So did you say 23rd September? Yep. Okay, thank you.
23rd September 2013.
Yep, thank you.
Mr Vik ensured that the Devon Park interest, we say, was removed from SHI for no consideration and kept away from the bank. All the administrative details of the transfer were dealt with by Mr Johansson, who said himself, as we'll come on to see, that he was managing the interest. Now, can I just say something about Mr Johansson? It's common ground, I think, that he ran SHI's day-to-day operations, and he was put forward by Mr Vik during the original trial proceedings as SHI's litigation consultant. And you can see that from the Court of Appeal's judgment, paragraph 8 in the Authorities Bundle, tab 2. It's clear, we say, that he occupied a far more significant role from Mr Vik, and he's described himself as Mr Vik's jack of all trades, and you see that in the Connecticut judgment in the 7th tab of the Authorities Bundle at paragraph 11.
He's described somewhere else as a factotum.
He is. And he provided 8 witness statements on behalf of SHI and or Mr Vik during or after the main trial in 2013, including the witness statements disclosing the sale agreement for the first time in 2014. Now, serious findings of dishonesty and fabrication have been made against Mr Johansson, and that was, first of all, at trial. The judge found that Mr Vik had been assisted by Mr Johansson to fabricate a document said to evidence the $8 billion counterclaim of SHI, and that he had then taken deliberate steps to disable computer functions which could have allowed the provenance of the document to be investigated. And that's section 33D of the trial judgment, especially paragraphs 142, 149 to 151. And that's in tab 1 of the Authorities Bundle. I'm sorry, I apparently misread that. 1542, 1549 to 1551. My energy tells me. Mr Justice Cook also held in the trial judgment at 1534 that Mr Johansson deliberately adopted an obstructive attitude in the face of a case management order he made, that aspects of his evidence were not credible, paragraph 1541, and that Mr Johansson, as it ultimately emerged, was not in any sense independent of Mr Vik and SHI. And that's at 1570, little 4. Subsequently, Mr Justice Cook held that several witness statements given by Mr Johansson on SHI and Mr Vik's behalf after the trial were so inconsistent with previous evidence given by SHI as to be incapable of acceptance. And that's the non-party cost judgment at paragraph 99, tab 3 of the Authorities Bundle. Now, we know that Mr Johansson played a key role with several of the asset transfers forming the subject matter of the bank's committal application. In his own words, he was responsible for the Devon Park interest, which he administered, and he was also closely involved in the partnership transfers, which we'll come on to. And in oral evidence to the judge, which is quoted at paragraph 431 of her judgment, Mr Vik described Mr Johansson as having been running everything on behalf of SHI since 2008. And according to Mr Vik, Mr Johansson also played a key role in assisting him to give disclosure under the Part 71 order. And the reference for that is Mr Vik's transcript and also Mr Vik's affidavit in the supplemental volume 3, tab 13, page 463, and the oral testimony is best picked up in paragraphs 427 to 431 of the judgment. Now, on Mr Vik's evidence, Mr Johansson lied to Devon Park about the true ownership of the Devon Park interest. And that's recorded in the judgment at paragraphs 99, 278 to 280. And Mr Vik tried to blame him for the misleading statements made in legal documentation. But what's clear is that Mr Vik was copied into key communications and signed relevant documents on behalf of SHI. So the attempt to distance himself is not borne out by the documentary evidence. Now, can I come back then to the evidence at the Part 71 hearing first? The bank explored this example of asset stripping at the Part 71 hearing, and Mr Vik's evidence was as follows. First of all, he said that SHI had entered into a sale agreement with his father's company, VBI, in 2012, pursuant to which, he said, all of SHI's non-cash assets were sold to VBI, including Devon Park. Secondly, he said that after the execution of the sale agreement in 2012, SHI did not, in fact, transfer the assets to VBI, but continued to hold them on trust until 2014. And thirdly, he said that in 2014, VBI purportedly gave SHI an oral instruction to transfer the interest to University, an entity with which Mr Vik claimed to have no connection with whatsoever and with no consideration being paid to SHI. And the evidence was all set out in the judgment at 206 and the Part 71 hearing transcript pages of the bundle. If one looks at 28, 34, 41 and 46 of the bundle, those are the relevant underlying passages. Now, standing back, that whole story is implausible for the following reasons. At the time, VBI was owned by Mr Vik's father, who was 87 years old and is now deceased. And the evidence shows that Mr Vik and his father were very close. And that's in 309 of the judgment. Mr Vik used his father's companies, including VBI, as repositories for a number of SHI's former assets, including some of the valuable private equity assets transferred out of SHI. And that's recorded in the trial judgment, certainly the use of VBI's depositories in 1435 little 4 and 1457, and also in Mrs Justice Moulder's judgment at paragraph 311. On Mr Vik's case, it was completely unclear why VBI would want a very valuable asset purportedly held for it by SHI transferred to a recently incorporated offshore company that Mr Vik knew nothing about. It was also unclear why SHI would have sold the asset to VBI in the first place in circumstances where Mr Vik had said his father had generously supported him without demanding assets in return. Now, the judge carefully considered Mr Vik's evidence on the Devon Park interest over 131 paragraphs of her judgment, and that's 209 to 340. And she rightly concluded at paragraph 341 that it was false. And there were 4 key reasons for her conclusion. The first is that, as we will see, she concluded the sale agreement was not a bona fide agreement. it was produced belatedly by Mr Vik in highly suspicious and self-serving circumstances. It contained terms which made no sense on the face of the document, served no obvious commercial purpose, and was uncorroborated by any contemporaneous document whatsoever. And I'll come back in a moment to the meaning of bona fide, but let me just give you the judge's other reasons. Second, the bank had obtained documents from Mr Johansson after the Part 71 hearing, pursuant to a subpoena in different proceedings. These had not been disclosed by Mr Vik or Mr Johansson for SHI in response to the Part 71 order, even though they were plainly responsive. And that's recorded in paragraphs 418 to 419 of the judge's judgment. It's not clear why Mr Vik did not disclose the documents, and the documents showed Mr Vik's story to be false because they clearly revealed that SHI continued to own the Devon Park interest outright until its assignment to Universal in 2014, thus entirely contradicting the suggestion that it had been sold to VBI in 2012. The documents also showed Mr Vik continued to have an economic interest in the asset long after its purported assignment to Universal in 2014. And indeed, it appears, as I'll show you, that he was personally due to receive a $44 million payment distribution from Devon Park as late as December 2015. And Mr Vik could provide no credible explanation for these documents in his evidence at the committal hearing. The third point is that Mr Vik was unable credibly to explain why VBI would have given SHI an instruction to transfer the asset to Universal. And that's paragraphs 306 to 311 of the judgment. And fourth, Mr Vik had a clear motive for lying about the improper transfer of this asset so as to avoid admitting it was another asset he had stripped from SHI to keep out of the bank's reach. Now, can I just pick up on the bona fide point, which I said I'd come back to yesterday? It was repeatedly said by Mr Matthews that the bank's case that the sale agreement was not a bona fide agreement was unclear. And he said that yesterday at pages 18 to 19, page 29, page 47 to 48, and page 49. Now that's not right. First of all, I showed you Mrs Justice Cockerell's judgment yesterday, holding that the bank's allegations were sufficiently particularised, and that included the allegation that the sale agreement was not a bona fide agreement, which was in the schedule at paragraph 4A, and that's in the core bundle, tab 11, page 310.
That doesn't tell us in itself what bona fide means.
No, but the whole point of that dispute was it was said the case wasn't clear, and that was not part of the application and not said to be the case then, although it had been in the run-up. The bank's case, which had been clarified, was that the sale agreement does not reflect a genuine commercial agreement between VBI and SHI. It is a sham. It is clear that Mr Vik understood that was the bank's case because he answered it in his written closing submissions below at paragraph 68C. And we've got inserts. It's not in the bundle, but we can pass that up to you.
So your case wasn't that it was a recent fabrication, but rather that it wasn't a genuine sale transaction.
So our case was that it wasn't a genuine commercial agreement and was a sham. What we have said is that the most likely analysis, given its late and highly suspicious disclosure, is that it was fabricated after the event. And indeed, Mr Matthews seemed to accept yesterday that it might not have come into existence until 2014. That was day 2, page 50, lines 3 to 50. And I put the case to Mr Vik at the committal hearings multiple times that it was fabricated. And that's in the supplemental bundle, volume 1, tab 4, page 161 to 162 and 189. And the transcript pages were 63, 66 and 34.
But of course, any fabrication would have had to have been pre a certain date in 2014,
That's right.
because we
So
know.
it's produced.
Yes, it was produced, and we also know that there appears to be some documentation that suggests it was around in April, I think.
So we know it's got to have been produced by then, and
Yeah.
it was actually produced in legal proceedings.
Yeah.
But what we say is, we don't know, and this is the point that Mrs Justice Cockerell made in her judgment, the bank can't know when it was created, but what we can say is it's clearly not a genuine commercial agreement, and that the most likely explanation is that it was fabricated, and even if it was created in September 2012, it was simply an attempt to create a paper trail for the improper transfer of assets out of SHI to VBI, rather than a bona fide arm's length commercial agreement. But, my lady, we put the case very clearly in our cross-examination of Mr Vik that it was fabricated, and Mr Vik has been under no uncertainty as to what the case is because he answered it in his closing.
Is there any significance to the 2012 date? I mean, I understand the 2008 transfers because a lot was happening in October 2008. But what was happening? Does it matter whether it was made in September 2012 or made in April 2014?
I don't think it does matter, except the whole point was it was produced in order to show that SHI had no money to pay the conditions that were sought for the condition of the appeal.
I understand that.
And I don't know, and we'll give some thought as to whether 2012, I'll double check, had any particular relevance. But all one can see is that it was probably created in the basis that it wasn't, we say, that it was so that it didn't look like it had been everything had been recently transferred before it was said that SHI had no money.
When was judgment handed down on the trial? That was
2013.
So by dating it to 2012, it predates the judgment being pronounced.
That's right. So it may be that.
Yeah. Thank you.
The problem is the bank simply doesn't know. But what we can say is, and I'll show you the agreement, it's not a genuine agreement. And even on its face, it looked dubious. But when you see the material we obtained, not from Mr Vik or Mr Johansson, it completely belies the story that was told.
Yes.
I mean, you say a document like that doesn't spring fully formed from the mind of its creator without a whole mass of surrounding documentation which simply doesn't exist.
Yes, I mean, that document can't appear on its own out of the ether with nothing to support its creation. And indeed, that takes me on to the new evidence, which I'm going to come back to, but 4 out of the 5 pieces of new evidence are trying to bolster the sale agreement. All of this material was available and would have been available to have been produced at the committal hearing below. So there is no basis to admit it now. The test your lordships have to apply is whether the evidence is necessary or expedient in the interest of justice. And we've set out all the relevant principles in the skeleton that we've served on the new evidence, which is in the unagreed document bundle, tab 2, paragraphs 8 to 12. And in particular, as part of that exercise, your lordship's required to have regard to, amongst other things, whether Mr Vik has offered a reasonable explanation for the failure to produce the evidence below, whether it's credible, and whether the evidence will afford or may afford a ground for allowing the appeal. And the starting...
This is not Ladden Marshall, is it?
No,
it's criminal evidence, and it's adopted by analogy, is it?
It is.
Yes.
I think it's section 23 of the relevant Criminal Act. So it's a different test, but broadly...
Is it a precondition to admitting the evidence that it could not reasonably have been obtained for the hearing below? It's not, is it?
It's not.
It's
so
a
not
factor to have regard to.
It is. It's a factor to have regard to.
Yes.
But what we say is it is the first factor before you get into the merits of the evidence. And the first factor in this case, which is very surprising, is all of this evidence, as I'll come on to show you, not only was available, but is actually all evidence that was evidence that Mr Vik was or must have been, we say, aware of and in his control, including, for example, the Klug memo, which he had actually adduced and relied upon himself in 2014. So I'll come on to show it to you. But what I will show you is some of that material, in particular the email from his solicitors, Zaroff, are produced to try and bolster the idea of the sale agreement. But what the email actually shows in the chain, not the email relied upon, but the one below, is that it looks like Mr Zaroff may have been seeing the sale agreement for the first time in 2014 or wherever it was, certainly not contemporaneously to 2012.
Well, the one point that sort of emerged from all of this that I think sort of struck me was that it couldn't be said. I mean, one of the points Mr Matthews was making was that it couldn't be said that it was a fabrication that had come into being late in the day for the purposes of the contempt hearing, for example, because it was definitely around in 2014. And there was a suggestion, I think, in the judgment that it was inconsistent with the AAA agreement, which, of course, that doesn't wash, does it, in terms of timing?
It's inconsistent on its terms.
Yes, that's the
the
point.
point.
Not inconsistent in terms of
That's
timing.
right. It's the terms, and I'll show you that.
Yeah.
So, can I show you the key documents that underpin this, starting with the sale agreement? I know we touched on it, but it is worth looking at this. It's in the core supplemental bundle at tab 27, page 675. So, the agreement, first of all, just to remind you, and I don't want to labour the point, was produced in April 2014, 2 years after it was allegedly entered into and after the trial had concluded in 2013. It was produced in the April 2014 witness statement of Mr Johansson, adduced by Mr Vik, in response to the bank's applications for conditions to be imposed on the appeal, and that Mr Vik be made liable for all the bank's costs. And it was a very self-serving document because obviously the whole point of it was to say SHI has no assets to meet the conditions. And it was produced out of the blue, no mention having been made of it during the whole of the trial in 2013, despite the fact that SHI's financial position was directly in issue at the trial.
And I think when it was first produced, the identity of the purchaser was withheld, was it?
That's right. So the other point that was very suspicious about it, my lady's right, is that when it was produced, the purchaser was redacted, and the witness statement of Mr Johansson tried to present the agreement, or did present the agreement, as being with a third-party purchaser that wasn't Mr Vik or Mr Vik's companies or connected with Mr Vik, and there was no justification for that redaction. And the only time we got the agreement, I think, non-redacted was pursuant to Mr Justice Tier's order on the Part 71 order, and it showed that it was, in fact, VBI, Mr Vik's father's company.
Why was the asset position of SBI relevant to the issues that Mr Justice Cook had to resolve?
So it was a core premise of SHI's 8 billion counterclaim that it lacked assets to meet the bank's margin calls, and the bank alleged Mr Vik had stripped SHI of its assets, and that's why the assets were SHI's continuing asset position was permanently focused upon, including where the assets had landed. And you see that in the trial judgment at paragraph 25 and 1432 to 1433. And then what you can pick up, and I'll just show you this, is Mr Justice Cook's judgment in the non-party cost order at paragraph 82, and that's at tab 4 of your second volume. And he he says at paragraph, it's at tab 2, I beg your pardon, of the authorities bundle.
That's the Court of Appeal.
No, I've got the wrong. It is
Tab 3, I
sorry.
think, isn't it?
Getting
It's the
there,
one we looked
sorry.
at,
It's tab
it
3.
earlier.
Yes, it is. Tab 3, sorry. And it's paragraph 82. And what you see is when the evidence is produced. So this is the occasion on which the court first looks at the sale agreement as well as the DBI note. And Mr Justice Cook says at paragraph 82, page 743, since SHI's financial position was directly an issue at the trial, both for the purposes of the arguments about the forced closeout, duress, available funds, October transfers, and also in relation to the starting fund and continuing fund available for the hypothetical portfolio, there is no room for new evidence relating to SHI's financial position which contradicts the findings in my judgment, or which, if it were to be admitted, could not assist Mr Vik. And the key point, my lord, sorry if it's not clear, is that the hypothetical portfolio loss claim ran beyond 2012. And that's why it came to play. And just to explain, I think you've understood from the term hypothetical portfolio, it was said by Mr Vik that he had kept a portfolio which he had traded in real time, which demonstrated, therefore, as a matter of fact, how much money he would have made had he had the starting fund and SHI had assets. And that's why he got to 8 billion. And of course, if there were other assets or asset movements, it would have made a difference to that claim.
But this particular interest, the Devon Park interest, was presumably an illiquid asset that couldn't be traded and couldn't be used to construct the portfolio.
Could have been sold to fund it, though.
Presumably that wasn't part of his case, otherwise it would have been...
Well, the case was that SHI had no money.
Oh, I see what you mean. Yes, okay.
So he could have said at trial, well, I did have this valuable Devon Park interest, but I couldn't have sold that to put SHI in funds to do all this wonderful trading because I'd already sold it to my dad's company.
Yeah. And at trial, SHI said it had used money paid by VBI to pay the trial legal fees. Sorry, the 2014 hearing. And that's why we think maybe 2012 was suggested, so that's when he said there was a payment of the 300 Norwegian kroner. If we look at paragraph 89 of this judgment.
So the suggestion was that the proceeds of the sale was used to fund the
Yes.
litigation.
Yes.
The later litigation.
Yeah, that's right. And therefore, at this point, they said SHI was insolvent. And contrast, as Mr. McDonald's pointing out, at paragraph 101, where SHI said at trial it was solvent.
What, as a matter of interest, has happened to SHI? Has it gone into any form of insolvency procedure?
We don't know.
You haven't
think so.
pursued it to insolvency?
No.
No.
We're told it has no assets. Yes. I mean, the point is that the reason why SHI was said at one stage to be solvent was because Mr Vik was trying to say that he would pay any judgment. He told Mr Justice Cook that he would pay any judgment that was made against him because he was an honest man. And Mr Justice Cook was recorded that in one of his judgments. But of course, by this point, he's saying it's insolvent. And that's why I showed you that passage from the Court of Appeal's judgment on the conditions it was said that they took him on board that Mr Vik could make the payment himself of the conditions if he wished to do so.
I see that although the identity of the purchaser was redacted, Mr Justice Cook hit the bullseye at the end of paragraph 87.
Indeed. Well, Mr Justice Cook had heard not only the 14-week trial, but years of interlocutories, and there were really many hard-fought interlocutories, as one sees with this type of litigation. So he had had quite a degree of familiarity with the case. So what the first point to make is that it emerged in pretty self-serving circumstances, no explanation for why not produced earlier, and in a slightly dubious way. And all of that was recorded by the judge in her judgment at paragraphs 211, 250 and 263. There were two further unusual circumstances. The first point, which we've already touched on, is that the document was produced without any corroborating contemporaneous documents. So no document showing BBI and SHI had negotiated its terms, no document showing when it was executed, no evidence of any involvement with lawyers, no email chain at all, which you can see by contrast with lots of the other arrangements that you see in the bundles. There are lots of emails going back and forth showing communications about any legal agreements. And although it purported to record the transfer of all of SHI's illiquid, complex, non-cash assets, no documents evidencing those transfers or communications about them were ever produced. And the second point, which you've already picked up on, is that it was produced redacted. And in a way, we say that it was done deliberately to mislead the court on the point, because Mr Johansson's statement, as the judge recorded, was designed to suggest the purchaser was not connected to Mr Vik. Now, going to the sale agreement, I've got 7 points on the sale agreement. First of all, it is unclear what assets were actually sold. So you see the sale agreement dated as of 26 September, and you see in the recitals the corporation wishes to acquire from the seller the assets attached hereto at Exhibit A, and that the seller is the owner of the assets, and there's a sale and purchase clause. And you see that the parties acknowledge some of the assets are illiquid, pausing on that sentence. If we go over to page 210, you see assets means all the assets described in Exhibit A attached hereto and made a part hereof. And then Exhibit A is at page 228. And this is the description of assets. Now this is a long generic list of assets. So you see it's all current and future assets of the seller, including but not limited to, the unusual phrase for a sale agreement, and then a whole list of different things, but excluding assets at the bottom, excluding cash assets, and the cash is not quantified. So this was it. There's nothing more, nothing specific about what assets we're talking about. And the purported assets were said to be the, as you've seen from the recital, illiquid and time-consuming, costly or otherwise complicated to transfer. Go back to page 209. That's the wording used. So you would have thought a purchaser might quite like to know what assets it was getting, particularly if they were costly assets. And the judge records all of this at 214 of her judgment. Now, it's only in 2015, so some 3 years after it said this agreement was made by the parties, that we get a list of assets which is created then by Mr Johansson pursuant to the order of Mr Justice Tier, and it's paragraph 6 of the schedule to the part 71 order. I don't know if you've seen that paragraph. It's in the core supplemental bundle, the same bundle, tab 19. So this is the Part 71 order, and here you see, just to make good some of the points I was making earlier, paragraph 1, the judgment debtor is to be questioned by the judgment creditor to provide information about the judgment debtor's means and any other information needed to enforce the judgment or order. And then you see the notes over the page. And then if one goes to page 137, this lists the documents to be requested. And paragraph 6 on page 138 is an unredacted copy of the sale agreement, together with a detailed schedule of all assets allegedly sold pursuant to the agreement. And if, while I've got you looking at this document, so we don't need to come back to it, if you just read paragraphs 2 to 5, you see the breadth of the categories, which of course were not limited categories at all. And it shows, when we come on to look at what was produced, what we got by way of the subpoena and Norwich Pharmacal, you'll see that they obviously did fall within these categories, so they should have been disclosed. Now, the schedule of assets that's then produced is at tab 33 of this bundle. And it's Mr. Johansson who does this. So we see here a list of assets including share options, film scheme investments, private equity investments, and other illiquid.
So did you say tab 33, which seems to be the same as page 228?
Right, I think we've had a problem with this insert. Can I get a copy? It's quite important if needed.
I've got a page 961 of tab 33.
It should be a page 267, and I think that you may have the same Exhibit A in that tab. That's what I had.
Yeah.
I've got
It
now the
is,
right document.
I do have page 267, but it is the same as
No, you
page
should have
228.
something different.
Ah.
Well, what's coming up on the computer screen is different,
Yes. Can I pass up?
except that it's illegible because it's sideways.
That's right. Can
Is
I
it-
pass up?
Is it just one page?
It is just one page.
Well, I have it.
It's headed Schedule of Assets Sold under
Yes.
Sale Agreement.
All right, let's have it.
Can I pass up 2 copies in this small form for now?
Yes, that's fine.
And can I just show Mr. Matthews that one of them is marked? Are you happy with that?
Yes, of course.
I'm sorry that they're in a size I can't read, but we will get you. We will get you proper.
It's the same
I think
size.
Lord Justice Nugee has it.
Yeah,
Thank you. We'll get larger copies.
I'm trying to rotate it on the screen, but without any success whatsoever. Thank you. Thanks very much.
I can cope with that. There's no need to bother
Yeah,
with larger
that's
copies.
fine.
So what you can see is this is the list. Now, the starting point is, you can see, this is the ex post facto document. Details of the asset are already set out in Exhibit A, including but not limited to the asset below. So again, it's not actually said to be exhaustive. And then you see the type of asset, which would have been pretty complex to value, would have involved potentially complex legal rights and potentially high-risk investments. For example, the Devon Park interest itself was a high-risk private equity investment, which required the purchaser of the interest to be required to make substantial and unquantified capital contributions in the future. So you would have thought that any bona fide purchaser would want to know exactly what it was getting for its 300 million kroner. The sale agreement didn't disclose that, and also what it was up for under it. And can I just make one point, which I'll come back to in the context of IFA. So the second one down, you see that what's said here is that SHI held those shares. Now, this is said to be the schedule of agreements at 2012 and produced in 2015. As you will have seen from the skeletons, Mr Vik's case was that SHI didn't hold the shares. So what we see is a document that's quite hard to reconcile in many ways with the sale agreement and Mr Vik's own case. The second point is that there is no contemporaneous document, as I've said, corroborating the purported sale of the asset. But when you look at this schedule now, you see just how surprising that is. Because it's inconceivable that documents wouldn't have existed relating to all of these types of investments, because it would have required extensive documentation to effect the transfers of these, or surely the purchaser would have wanted to see the relevant documentation.
Can I ask you something? This goes back to what you mean by not bona fide. I entirely understand that the sort of points you're now making make it unlikely that a wholly arm's length third-party purchaser acting commercially would have bought this collection of assets without doing a great deal of due diligence.
That's right.
But we know the purchaser was not an arm's length purchaser. We know it was Mr Vik's father's company. I think I've understood. Your point on bona fide goes beyond saying that he wasn't acting commercially to saying that actually it wasn't a sale at all.
That's right. It's a sham agreement. Whether it's fabricated in 2014 or a sham in 2012 is by the by, but it's a sham agreement. It's not a genuine, legitimate commercial agreement.
Well, I don't. It's the way you put in commercial there, which is causing me doubt, because
Right.
it
It's
is
not
entirely
a genuine, legitimate agreement.
It's entirely possible to envisage a world in which somebody goes to their father and say, "Will you buy this collection of assets from me? I'll let you have them for 300 million credit. Actually, they're worth a great deal more, but don't worry about doing due diligence. Just take it from me." And a father saying, "Yes." I mean, that would be a bona fide agreement, but it wouldn't be a commercial one.
Yes.
Do you see the?
I do. So we are saying that it is not a bona fide agreement. I don't need the word commercial. Yep. The reason I'm putting commercial in is because obviously this is a layered point in the sense that...
Well, you've made the point, which I understand entirely, that no ordinary purchaser acting commercially would buy this collection of assets without doing a great deal of investigation.
And the reason I'm labouring that point, I'll come on to the next point about it being Mr Vik's father, is that I just have in mind the way this was presented. We'll find a reference. I'm not sure we've got the evidence in the bundle. We may have to give it to you. In Mr Johansson's statement, this, of course, was presented as an agreement with a arm's length purchaser, no connection to Mr Vik.
Yes. So
it was presented in that way. So that's the first target to show that the way that this was produced and presented is just not true, which is a plank in undermining Mr Vik's case. The next point...
I mean, it might be quite important to see whether Mr Johansson actually uses words like arm's length, no connection to Mr Vik. I mean, what we've seen in Mr Justice Cook's judgment that you just took us to on the non-party costs or the conditions was that the purchaser didn't want to become embroiled in litigation with the bank, which might imply that it's an arm's length purchaser, but might equally be true of Mr Vik's father.
We'll find it for you. What you can see is that Mr Justice Cook obviously took the view that the evidence that had been given to him was designed to create an impression. And that's what I've shown you. We'll find it.
Yes.
So,
Well, Mr Justice Cook certainly was alive to the possibility that it might actually be somebody who was connected, because he even, as my lord said, comes up with the possibility that it's VBI.
yes, but I think that's because of the nature of the agreement and knowing Mr Vik. But we'll find the evidence.
Anyway, you find it because there may be a distinction between creating an impression and outright lie, if that's what was said.
So, paragraph 16 of the sixth witness statement of Mr Johansson.
Is this in a bundle somewhere, or you're just...
Well, I'm reading it off because Mr
Yep, all right.
Donald seems to have access to all documents. It's not in the appeal bundle, so we'll have
Okay.
to use a copy. And it says, in 2012, SHI sold its then remaining non-cash assets to a third party pursuant to a purchase agreement dated as of 26 September 2012. And then it goes on to say, under the terms of the sale agreement, SHI sold all of its non-cash assets, etc., for consideration of 300 million. It was agreed between SHI and the purchaser of the assets that the identity of the purchaser would not be disclosed, and as such, the sale agreement had been redacted appropriately. The purchaser did not want their identity revealed because of a concern that the purchaser was not Mr Vik nor a company controlled by Mr Vik.
Well, that was strictly true.
But it was obviously designed to give an impression, as Mr. Justice Cook said.
But it didn't mislead Mr. Justice.
No.
Can I ask you something else, Robert? Just as you read it, I was struck by the fact that Mr. Johansson does not say it was executed on the 26th of September, but says dated as of. And when you look at the document itself, not only on the cover sheet, but on the execution page, it says dated as of. Was there ever any contention or evidence or suggestion as to when it was actually executed?
I will have to check that. My recollection is that there was a dispute over the dating, and it was again pointed at as evidence of it not being a genuine agreement. And my understanding, the best I can recollect, is that the response from Mr Vik's side was that it was executed on or around that date, and that's why it had that date. But we'll have to check that. But we obviously took the point that it was very strange wording. And I think there was also the other point that we made was that the agreement says effective as of the closing date, and the closing date is defined as the date on which this agreement is initially exchanged for value. So again, we pointed out that as being a very strange wording for a legitimate agreement.
It's odd, but you could see that it might correspond with the handing over of the 300,000 kroner or 300 million kroner.
Yes, we took the various points on the face of the agreement. Now, moving on then to Mr Vik's father point, the sale agreement had no discernible rationale from SHI's point of view, because Mr Vik said the sale took place because his father wanted to advance cash to help him. But as the judge pointed out, on Mr Vik's evidence, his father had been previously content to lend generous amounts of money to SHI to help it with its financial difficulties. And the words he used were, "My father was very nice to me and was very helpful in financing Sebastian Holdings." That's quoted in the judgment at 212. And Mr Vik also said that his father was very helpful and provided a huge amount of money to SHI. And it was said that there are obviously various loans from VBI as well. And on this basis, SHI had no need to sell all of its assets to VBI. It could have just kept borrowing money. And that was recorded in the judge's judgment at paragraph 250. And one of the points that came from this was Mr Vik couldn't really explain why this approach had been taken, because if it was an informal agreement of the type that my Lord Justice Nugee was referring to earlier, why you would go to these lengths to document the agreement and document it in this way, and it wasn't consistent with the pattern of dealings that Mr Vik described or sought to rely on with his father in other contexts.
Well, I get the point about the absence of an explanation and the inconsistency, but it's not beyond the realms of possibility that if a parent, say, is happy to help out their son by advancing sums of money over a period of time, that after a while they say, well, hang on, you've actually got something of value. The problem is that you're asset rich and cash poor, and I'm not just going to keep giving you handouts without any form of security for what I'm paying to you. So in future, what I want is some form of assurance from you that I will get repaid. And you could see, hypothetically, that sort of arrangement.
But that wasn't part of evidence given.
Quite. I mean, the real point is that that's not what Mr Vik said to explain it.
And you've got the reason I'm going through all the circumstances is that as a picture, and obviously this is the approach that is advocated in so many cases, I think one of the Abiazov cases by Justice Crystal Clark, that you've got to look at everything together. And as you piece all this together, which you can see the bank has had to do over a number of years, through a number of different routes. And just to answer, I think, the question of Lord Justice Nugee, it was at the Part 71 hearing that Mr Vik said it was done in 2012. So the questioning was at day one, day one, it's the Part 71 hearing, supplemental small bundle, tab 1, page 36 of the bundle, page 175 of the transcript, lines 6. The agreement, I put to him, well, it's dated as of, so we don't know when it was signed. He says, what's the date of it? 26 September. So obviously it was finished and the deal was done, and SHI needed money and they paid advance for that.
I see that although the list of assets is very generic, as you say, there is a specific reference to Devon Park on the following page about permitted encumbrances.
Yes.
Is there, so whoever prepared this document seems to have had Devon Park in mind. Is there any significance in that?
I don't think so, my lord. Or what you would say is that if it was right, you would expect then to see a lot more correspondence about Devon Park, and we'll come on to see what we do see ultimately.
Right. Okay.
And obviously, this doesn't list some of the other things we see, IFA, but of course IFA...
No, I follow that.
Yeah. My lord, can I just make one point, which I appreciate is slightly undermining my own submissions, but obviously I am showing you the material that formed the basis of the judge's conclusions, and the job of this court is obviously to see whether they were in the realm of a reasonable judge. And it's important, although each bit of evidence may be looked at by this court, it isn't a rehearing of what this court would necessarily have done. Now, obviously, and one has to show that that the judge, looking at all of this evidence, just could not have reached the position she did. Now, the fourth point, my 7 points, is that the sale agreement was also ineffective under its own Norwegian governing law. And this is the judge's judgment at 252 to 263. So if we look at section 7.7, which is on page 224 of the judgment, of the document, this provides that the laws of Norway govern it. Now, section 4.1, which is on page 214, then has trust provisions for the assets. And as the judge found, and as Mr Justice Cook found on the evidence before him, which was put in by both sides, and I'll come back to that, a trust is not recognised in Norwegian law. And I'm going to show you the Klug memo, but actually Klug agrees with that. There's no dispute that a trust isn't recognised under Norwegian law. Now, Mr Vik tried to explain this mechanism on the grounds that the agreement provided for the assets to be transferred to VBI over time. The judge, however, was right that nothing in the agreement provides for the assets to be transferred to VBI over time. That was her finding at 258. And when Mr Matthews addressed that on you yesterday, he wasn't accurate about the judge's findings. He addressed you on this at day 2, page 48 of the transcript. The judge did not say in her judgment that the sale agreement did not provide for the assets to be transferred over time in general. Her point was that it didn't provide for them to be transferred over time to VBI. Rather, the unenforceable trust provisions contemplated that the assets would or could be transferred to a third party rather than VBI, although a transfer to VBI was not ruled out. And that's what she found at 260 of her judgment. And if you look at section 4.2d, that provides for the seller to transfer the assets on VBI's instructions to whomever VBI requests.
Well, that's consistent with universal transfer, isn't it?
That they could have had an instruction to do so. Yes, but one would expect to see documentation and an explanation of who Universal were.
Well, why would they have to say who Universal were? Because if just postulate this as a genuine arrangement for the moment. The purchaser doesn't want to have physical possession of the assets for whatever reason, leaves them in the hands of the seller, and does so under an arrangement whereby he can say at any stage, transfer them to X. Well, it's his business who X is, isn't it?
Of course, but one of the points that Mr Vik's relying on is that he has an informal, close relationship with his father. So if that's right, and his father is not a young man at this stage, who Mr Vik said was not over the detail, you would expect Mr Vik, as a responsible person dealing with it, to know when he's getting instructions, first of all, how did the instruction come, and is it documented, and what's the terms?
In other words, is it genuinely coming from Dad?
Exactly.
Yes.
Exactly. And a Panamanian offshore company may be something that one would want to know about. But the whole point of this as well is that the trust is itself hard to square, A, because it's not legitimate under the law of Norway, but B, look at section 2.2a. This provides for a complete transfer of all the assets, not a split of legal and beneficial ownership.
But some assets, well, it doesn't matter if you execute a deed in this form, some assets require to be transferred using their own procedures. You know, shares need a stock transfer form and so on. So you can have a contract like this which says, we immediately transfer this to you, but then you also have a covenant for further assurance if something specific needs to be done to actually effect a legal transfer. But that by itself is not unconventional, is it?
That's not, but if you're transferring forever all your title in all the assets, but you're also saying they're held on trust.
Yes, I see.
Which is the case that's been advanced.
I mean, 4.1 is slightly unusual.
And what's very unusual then are the 2 points that the judge noted. One, Mr Vik couldn't explain any of this except to say that all the arrangements between him and his father were very informal. At which point the answer is, well, why do you have the agreement at all? Because this is a formal, detailed written agreement. So you would expect it to make sense. She made that point at 252 of her judgment. Nor does it explain why it was redacted when disclosed. And nor does it explain why it's not been possible to identify who drafted this agreement and how it came into being. And
what was the evidence? Mr Vik was asked who drafted it, was he?
He was, and he couldn't explain. The position is that he couldn't provide a credible explanation of who drafted it, even though he must have known. And if lawyers had not been used, which was one of the sort of lines of questioning, because Norwegian lawyers wouldn't have drafted an agreement containing a provision unenforceable under its own trust law, and he couldn't say who had drafted it, then the pool of potential drafters must have been very small, and their identity would plainly have been known to Mr Vik. And the obvious candidate here is Mr Johansson. And the references in the judge's judgment are 264 to 265, where the judge notes this. Now, one point just to pick up while I'm on the Norwegian law points is that Mr Matthews sort of gave the impression yesterday that it was somehow central to the judge's reasoning, and that was at day 2, page 20, and day 2, page 29. But if you read the judgment carefully, you'll see that the judge actually didn't place that much weight on the point in the abstract, which is something my Lord Justice Nugee picked up on, and that's at day 2, page 28 of the transcript. What her point was is that it showed that lawyers were unlikely to have been involved, and there was some evidence VBI had access to Spanish lawyers, but they obviously wouldn't have drafted a Norwegian law document. And you see the judge explored that at paragraph 266 of her judgment. And if you look at paragraph 255 of her judgment, in fact the judge gives the benefit of the doubt to Mr Vik as regards the unenforceable trust law provision, saying it could be explained by informality. But she goes on to use it as the basis for her inference at 265 that lawyers weren't used. So the Norwegian law point was not fundamental to her reasoning, except to show that it seems unlikely lawyers were used. Mr Vik didn't suggest that he knew that lawyers were used, wouldn't say who did it, and therefore it must have been somebody else, but Mr Vik wasn't saying who. The sixth point, I've got 7 as I said, is that it's also significant that Mr Vik produced no contemporaneous documents about the VBI instruction to transfer Devon Park to Universal. And this is recorded in the judgment at 268 to 271. Now, as the judge pointed out, Mr Vik's evidence is that it was not only his father, but VBI's president and managing director, Mr Blanco, from VBI's side, who was involved in the decision to implement the transfer. There is no evidence that Mr Vik had an informal relationship with Mr Blanco, and his evidence at the Part 71 hearing was that he only spoke to Mr Blanco once or twice a year, and that's in the Core Supplemental Bundle, tab 1, page 10, transcript pages 163 to 164. And acting in VBI's best interest, Mr Blanco would plainly have wanted to document instructions to transfer a 44 million private equity interest to a recently incorporated offshore vehicle. And there's no documentation to show that. The 7th point is that the conclusion reached by the judge that the sale agreement was not bona fide was not just a question of looking at the document and the circumstances of its production and the terms and drawing the inferences, even though what I've shown you alone and Mr Vik's inability to give proper explanations, we say, would have been more than enough to show he was lying. In addition, she had all the documents obtained from the subpoena that the bank had access to, which showed the sale agreement wasn't a bona fide agreement. So can I turn next to what we're calling the Johansson documents? So not produced in response to the Part 71 order, despite I've shown you the terms. And there are formal signed agreement documents transferring SHI's interest in Devon Park to Universal in 2014. And the documents were negotiated by Mr Johansson with Devon Park, and Mr Vik was copied into key emails about it, even though he tried to suggest it was nothing to do with him. And if we could go to the supplemental volume 3, tab 32, page 841. the email of July 2014 with Devon Park sending the assignment agreement to Mr Johansson for review with Mr Vik in copy. And Devang Kantasari is Devon Park. If we go to page 842 at the top, we see an email of the 19th of August 2014 from Devon Park to Mr Johansson, showing that SHI has made a request to delete section 5C from the agreement, which Devon Park has agreed to. And it's copying again Mr Vik, and they say they're coordinating the transfer of the Sebastian interest. And the judge held that this email showed that Mr Johansson was negotiating the transfer and paying attention to the detail of the transaction documents. And that's paragraphs 274 to 275. Now, the documents proceed on the basis that SHI owned the asset outright. And the first document which you've seen is the AAA itself, which the judge considered at paragraphs 216 to 218 of her judgment, and is in the core bundle at tab 29, core supplemental bundle. And on its face, it provided for the transfer of the Devon Park interest by SHI to Universal as of August 29, 2014, and it's said to be made by and between Sebastian Holdings and Universal. And the document was negotiated by Mr Johansson with Devon Park's lawyers, and the document showed, as the judge found, that it was Mr Johansson's responsibility to do so, and that's at 274 of her judgment. Now, it's common ground that the document was signed by Mr Vik himself, and I'm afraid annoyingly again, this is in the third supplemental bundle, tab 29, page 806. There it was signed by Mr Vik. And the first and second recitals of the AAA, whether you look at it in that tab or in the core bundle, you can see that it provided that the assigner owns a limited partnership interest in Devon Park and wants to transfer it, and the assigner and owner is SHI. So there's no suggestion that VBI has any interest whatsoever. And in addition, clause 3C, which is at page 237, contains a warranty of title from SHI as to both the legal and the beneficial ownership. So you would expect to see, as my Honourable Justice Nugee observed, when you've got lawyers involved and somebody carefully negotiating it with the detail you've seen from Mr Johansson removing sections and so on, explaining that SHI is transferring the asset on VBI's instructions. And my learned friend tried to suggest that this statement was just a minor slip or oversight, this clause. That was at day 2, page 35 of the transcript. But warranties of title are fundamental, and a false warranty would render SHI, Mr Vik or Mr Johansson potentially liable in fraud or negligent misrepresentation. Now, when all of this was put to Mr Vik, he reverted to his usual tactic of suggesting that he had misled Devon Park in some way. And you can see that in the core supplemental bundle, tab 8, page 66, of the bundle, page 77 of the transcript. Get me to turn it up.
Misled Devon Park?
Well,
the person who'd have to be misled would be Universal. Well,
he's saying that they kept their cards close to their chest, I think may have been the expression, or something like that, from Devon Park, and didn't tell them very much.
Well, that doesn't explain it away, because if I can understand Mr Vik saying, well, my arrangements with my dad were nothing to do with Devon Park. That it was our interest in Devon Park. We didn't need to tell them on a need-to-know basis that I'd entered into an arrangement, call it a trust, call it whatever, whereby our interest was sold to somebody else, but we were holding it for them. That I completely buy. What I don't buy is the idea that the person who has got to know of this, which is Johansson, who's right in the web of it all, and Mr Vik himself, would then think that they could get away with with transferring it to Universal without actually revealing the position.
Well, there are 2 points, my lady. You're absolutely right. First of all, the warranty, though, is a material inducement to the general partner
Right.
of Devon Park,
Okay.
and clause 7 to the same effect,
Yeah.
which if you're used to the supplemental bundle 3 for that. So that's why Mr Vik had to revert to we weren't telling Devon Park
okay.
everything.
Okay.
And we'll come on to Universal in a moment. And you see at page 808 of the bundle, Devon Park's consent.
Yeah.
And the reason for that, my lady, is that Devon Park has to be satisfied as to the person making the capital contributions.
Yes.
So that's why they need to know. And what you're going to come on to see, their concerns about Universal.
Understand the need to know that Universal is good for the money. Why do they need to know, as between Mr Vik and his father's company, where the beneficial interest is? And there's no suggestion. I mean, normally you give a covenant for title, representation, but warranty of title, to protect the purchaser against some third party coming along and saying, actually, it's my asset. But Mr Vik's father's not going to do that. So as my lady said, if what was going on was that Mr Vik was not telling Devon Park about his father's interest, why does that prejudice Devon Park?
Well, my lord, can I just roll back a second here? What we're looking at is a story that Mr Vik has put forward to the court, that he has transferred everything to Devon Park, and to a VBI.
And you're trying to say that story doesn't stack up.
Yes, and then what's
one of the reasons you say it doesn't stack up is because this representation and warranty in 3C shows that Devon Park were under the illusion that the assigner was Sebastian.
Yeah. I'm going further than that. What I'm saying is that there are legal agreements that are legal and binding, that involve lawyers, that involve negotiation, that appear to make statements on their face that are inconsistent with the factual position that Mr Vik has put forward, because it's saying that SHI is the legal and beneficial owner, and that no explanation was put forward fully at the time in evidence, for example, that VBI didn't want, we didn't tell anybody about VBI, but we signed these agreements illegally.
I thought you said that was the evidence.
That came out when this was put to him. It's his answers that come out when you put the documents and he's thinking on his feet. It wasn't in his affidavit, it wasn't part of the explanation put forward, but also you're giving him the benefit of the doubt that it doesn't matter what Sebastian signs, and that they can keep the truth from the general partner because what harm is done when this is a legal agreement.
I mean, your broad point is that if the sale agreement had been a genuine document, then somebody would have told the lawyers, actually, these interests are held on trust for VBI, and we need to draft the documents that way. I mean, is it really as simple as that, or is there more to it?
It is that, but it's also the other point, which is you would have some document, you'd have something from VBI about this transfer, you'd have some record to Devon Park that it was being held on trust for VBI, because why not say that? What's the problem with saying that? Particularly when you're getting into detail on legal agreements, why not just record that? Or why not have a record between VBI and Mr Vik as to what was happening, or SHI? I think at the moment you're looking at these documents as if to see whether you can establish there's any reason why Devon Park would have a problem. But what I'm saying to you is that these documents weren't produced by Mr Vik. They're inconsistent on their face with his story. They're legally binding documents. They're not ones that were just signed because Mr Johansson negotiated them and corresponded about them. And no positive explanation was put forward. When he's cross-examined, he ends up saying, oh, well, Devon Park may have been misled. And why would you, put another way, why would you give a warranty you know to be false?
Because you're never going to be sued on it.
How do you know, my lord?
Well, because you'd only be sued on it if VBI did come along and claim an interest, and you can trust your dad is not going to do that. I mean, what we're trying to get at is whether this warranty assists in the judge's conclusion that the 2012 agreement was not a bona fide agreement. And by this time, it's already been disclosed.
Well, my lord, the two things are, first of all, that it's not the job of this court to look at what decision you might have made. So
I understand that.
This document is perfectly legitimate as a ground for the judge saying it undermines Mr Vik's story, because on its face, it is inconsistent. A warranty, I know you may disagree, my lord, but a warranty in a legal document that somebody is the beneficial owner when they are not is undermining. And there was no explanation in evidence as to why that would have been necessary. And I know your lord said this is my father's company, or his father's company, but Mr Vik was, senior was 87, he's now deceased. There are other people involved in running the company. Whatever informal arrangements Mr Vik might have reached with his father may not have been upheld, particularly if they're not documented by anybody else involved in VBI. So why take any of those risks if this is all above board?
Well, you can see that commercially, given the age of Mr Vik's father, and assuming that everything is undocumented, there is always the scenario that as and when Mr Vik's father dies, his estate, or indeed those left behind managing the company, might look around and say, well, let's assume the sale agreement's genuine. Let's sort of call in on the sale agreement and then discover it's all been transferred to Universal and say, well, what's going on here?
Right. And can we just look at...
Although Universal is another manifestation of Mr Vik's father.
Well,
We don't know.
not according to Mr Vik. And indeed, if he'd said that here, that might have given some credence to Justice Nugee's point that none of it really mattered. But of course, Mr Vik's case is that Universal has no connection with him. So...
But what I take from this, tell me if this is wrong, is that the person who drafted this, which is Devon Park's external counsel, didn't know about the sale agreement. And there are two possible explanations to that. One is it didn't exist, but we know that by April 2014 it had already been disclosed. So it's not as if this proves that the idea hadn't occurred to anybody.
It proves it wasn't a bona fide agreement.
Yes, the other explanation is it wasn't. It was a sham.
We know it existed.
Yes,
at this point on paper. What we're saying is it's a sham. And this shows it was a sham.
It shows it's inconsistent with it.
Well,
and you have to get a very convoluted and somewhat difficult to accept explanation. But even your point, Mr Larney, at the end of the day, is it doesn't matter because it was open to the judge to say this is inconsistent.
Exactly.
And irrespective of whether we would have accepted it or thought that on giving the benefit of the doubt to Mr Vik, there was another explanation that might just about wash its face, it doesn't matter because it was open to the judge to say, on the face of it, you wouldn't have this document if the sale agreement was a genuine one.
Exactly.
That's your point.
My point is that, and I'm going to develop, if I may, that point, which is the reason I also say that is, I'm going to just show you the what the judge recorded as to Mr Vik's evidence, because the difference between the judge and this court is, of course, that the trial judge hears and sees the evidence. And this is not a decision that was reached on the basis of looking at these documents and positing the different explanations, which I accept there are explanations, although I do think a legal document is a serious thing to sign if it's untrue. But the judge actually gave the opportunity to and heard Mr Vik explain this, and she didn't accept what he said. And that's why this court can't put themselves in the court of the trial judge unless there's an error so unreasonable that it takes into that territory. So Mr Vik was asked about this as recorded in the judgments at 272 to 281, and he made various attempts to explain the documents. His first explanation was that he had not read the assignment agreement, and that was recorded at 272 to 273. And SHI solicitors at trial, Travis Smith, gave evidence that Mr Vik was central to the proceedings and that they couldn't do anything without his involvement. And that evidence from Travis Smith was given on Mr Vik's instructions when it was being said that he needed more time to deal with things in the litigation. And the judge was aware of that. And that evidence was put to him at the committal hearing, and he changed his position and denied having any central role. And that was at Supplemental 1, Tab 3, page 130 and 136. I think that may be the Part 71 hearing, so I'm just looking at the reference. The judge observed in paragraph 276 that Mr Vik was dissimulating in an attempt to head off questions about his close involvement in the transfer, and that the clear inference to be derived from the documents was that Mr Johansson was acting on Mr Vik's instructions. His second explanation was that he and Mr Johansson had made effectively a deliberate decision to keep the prior sale to VBI secret from Devon Park. And that was in Supplemental 1, Tab 3, page 124 at page 93 of the Part 71 transcript. And that was quoted in the judgment at 278. As the judge pointed out, that directly contradicted the evidence that Mr Vik had given that he had no involvement in the transfer. And effectively, he was left submitting that the sale agreement was deliberately misleading of Devon Park, and in his closing submissions, it was said SHI was less than open with Devon Park, paragraph 74B of the closing submissions of Mr Vik, Supplemental Volume 3, Tab 18, page 360. Now, Mr Vik's skeleton for this appeal advances a yet further inconsistent explanation. So we're now on the third explanation, and that is that the sale agreement might have been ineffective to transfer title to the Devon Park interest to VBI. And that was a point repeated by Mr Matthews on day 2, page 27. And that's an extraordinary volte-face from Mr Vik's evidence.
That's the Norwegian law point, is it?
Yeah. And that's a new point, and it's changing the position from the conditions hearing and the Part 71 hearing, which was that the sale agreement was effective to transfer title, and that's why SHI's assets were no longer available to meet the judgment debt. And he didn't advance any case below before the judge that the sale agreement was ineffective. But the fact that he keeps on changing his case gives a measure of why the judge found it hard to accept what my Lord Justice Nugee said might have been a legitimate point, but you can see that the way the evidence came out and is coming out, and the case is coming out, makes it incapable of belief. I'm just going to check, my Lord, because I heard some muttering that it wasn't just the Part 71 hearing that this was at, but I think the references are to that.
It's not Part 71.
No, it's tab 1. They're all tab 1. Yeah. It's all tab 1, the references. Can I deal then with Mr Vik's criticisms of the judge's findings on the sale agreement? And sorry, before I do, can I just, what the last document I better show you on this run is at tab 30 of the supplemental bundle, either the core or volume 3, whichever you're working from. And that's the joint written instruction. And it's the transfer by SHI of its interest to Universal. So again, this is being said to JP Morgan and signed by Mr Vik. So it's not just to Devon Park. Manuel, can I just correct that it's supplemental volume tab 1, sorry, supplemental volume 1 tab 3. Mr Matthews is correct. It was tab 3. So it's those references are to the committal hearing, not the part 71, just to be clear.
Okay.
So can I then go to Mr Vik's criticisms of the judge's findings on the sale agreement and briefly deal with the new evidence on this topic? So we deal with all of these points in section E3 of our skeleton. I'm not going to go through all of them, but I'll take the key ones. He devotes 31 paragraphs of his skeleton, paragraphs 129 to 150, to various criticisms, and we suggest that they're all not legitimate criticisms of the judgment. First of all, he says the judge shouldn't have placed weight on the lack of corroborating documents in the late disclosure of the sale agreement, but the sudden appearance at the blue of it, without any contemporaneous material, did cause suspicion, and no good explanation has ever been provided. And Mr Justice Cook thought so too, so Mr Vik was on notice of the fact that an explanation was required right from 2014, but couldn't provide a proper explanation. And the fact that subsequent materials that we obtained from Mr Johansson weren't disclosed but appeared to undermine the case and themselves couldn't be explained, fed into the judge's judgment legitimately. The second point is Mr Vik says that the assignment agreement and the escrow agreement do not demonstrate the sale agreement to be a false agreement. And we say that's hopeless because both are formal documents between SHI and reputable third parties, the escrow bank, JP Morgan and Devon Park. And again, we say that no credible explanation has been provided as to why SHI was presented as the owner, and no explanation as to why it couldn't have revealed that VBI was in fact the owner and they were holding on trust. The third point is that the judge is said not to have taken into account the VBI and Universal agreement dated 9 July 2014. And it's said in Mr Vik's skeleton, he plainly would have wished to put this in evidence. So paragraph 135. Now this is another example of a volte-face from Mr Vik's position, as I think my Lord Justice Mayles pointed out. The document was disclosed on the 21st of August 2019 in Delaware proceedings, and those were brought by Deutsche Bank against SHI, Devon Park and Universal to challenge SHI's transfer of the Devon Park interests. This was after Mr Hart's first affidavit in support of the committal application had been sworn in May 2019. Now, it was disclosed in those proceedings to Zaroff, Mr Vik's own lawyers. But Mr Vik made no reference to the document in either his skeleton argument for the hearing before Mrs Justice Moulder or his affidavit, which was served very close to the start of that hearing. And when my learned friend said that the document had been disclosed to Deutsche Bank on day 2, page 35, he didn't mention to the court that it had also been disclosed to Zaroff, Mr Vik's own lawyers. And he went so far as to assert Mr Vik has not seen it. Now, Mr Vik, however, was the person who first raised the existence of the agreement because his solicitors, Brecher, sent a letter dated the 29th of April 2022 referring to the document's disclosure in the Delaware proceedings, but not explaining how they became aware that it had been disclosed. And the letter was sent prior to Mr Vik swearing his affidavit on the 2nd of May 2022. Brecher sought an immediate explanation why the bank had omitted reference to the document from Part 1, to which the answer was, well, that affidavit predated the disclosure, and they accused the bank of seeking to convey an incorrect impression. And they referred to a paragraph of the bank's skeleton for the committal hearing, saying that it was inconsistent. The bank had said the assignment agreement is completely inconsistent with a prior sale of the Devon Park interest, and Mr Vik said, oh, this document undermines that point. At that stage, my instructing solicitors filed and served evidence explaining that no one involved in the preparation of the bank's skeleton argument had any knowledge or recollection of the particular document from those other proceedings. And the bank tried to put that document in evidence, Mr Vik having said, without it, the position wasn't clear. Mr Vik resisted it being put in evidence and said he knew nothing about the document. And that was referred to in the judge's judgment at paragraphs 282 to 283. And in his closing submissions, he insisted it was a document he had not seen and quotes, which is not in evidence. And that's in the core supplemental bundle, tab 18, page 133 at paragraph 46. No explanation has still been offered as to how Mr Vik's English solicitors learned of its existence. And for its part, the bank hasn't placed any reliance on the document as the judge recorded in paragraph 283. So the judge, plainly in those circumstances, was entitled not to take the document into account. Mr Vik's position was that the bank wasn't permitted to put it in, and it wasn't in evidence before the court. And notably, despite the raft of applications to adduce new evidence on this appeal, Mr Vik has made no application in connection with this document. And Mr Matthews tried to say yesterday that the bank had put it in evidence below, but you've seen that his own position was, and the judge's was, it wasn't in evidence. So the idea now on this appeal that the judge made an error because she didn't give any weight to a document that was not in evidence before her, because Mr Vik resisted it going in and has still not adduced it, is absurd. And so too is the suggestion that was made to my Lady Justice Andrews that the judge was obliged to take it into account. That was at day 2, page 37.
Well, I pushed Mr Matthews on that because it seemed to me that he had to go that far in order to get any mileage out of it, because you can't criticise a judge for not taking into account something that is, on the face of it, irrelevant or isn't in evidence, unless she should have admitted it into evidence and was obliged to take it into account.
Yes. So that's the history, and there's a statement from my instructing solicitor, Mr Robertson's fourth statement, which tried to, when the bank was accused of being misleading, explain the position, exhibited the document, and we were met with fierce opposition, and in the end it was put to one side because it was seen as an unfair point to Mr Vik. So the idea that that now is being put in the way it is just simply not correct. The fourth criticism Mr Vik makes is to rely on a schedule of bank transfers prepared by Mr Johansson, which purported to show money is being transferred by VBI to SHI pursuant to the sale agreement, and that's in his skeleton at 139 to 141. And what Mr Matthews said yesterday at page 45 of the transcript was that these, quotes, payments undoubtedly took place, close quotes. Now, there was no evidence that these transfers were payments. All that was said was that there were transfers. And Mr Vik adduced no documents to show...
When you say no evidence they were payments, you mean payments pursuant to the sale agreement?
Exactly,
Yes,
exactly. Or for what purpose?
Yeah.
They were just simply... and
So the fact of money being transferred is established, but all the rest you say
exactly.
not.
And that's why the suggestion that it's the payments of the sale monies undoubtedly took place. No evidence supporting that was adduced. And what we know is that VBI had previously lent money to SHI, so we can't assume that simply because there were payments, there were transfers rather, there were payments under the sale agreement without any other documents corroborating that. And Mr Vik claims that Mr Johansson's schedule, which is not in the appeal bundle, was not disputed by the bank, is wrong. The bank never accepted that they showed anything other than the movement of money.
So it's true to say, if this is what Mr Matthews meant, the payments were made in the sense that the money was transferred.
Yes.
The question is, how do you characterise them?
Exactly.
And you
And
never accepted that.
No. And what we would say is that Mr Vik's evidence was that his father was very helpful and had provided a huge amount of money. So what we haven't had said is the only money that would have been coming was in response to the sale agreement. He said that he got a lot of money from his father, so presumably for lots of different purposes, and no other evidence was produced. And just while I'm on this point, we can give Mr Vik a lot of the benefit of the doubt, but the one salient point I'd ask the court to have in mind is all the missing information where my Lord Justice Nugee or Justice Wells is seeking in a way to fill in what might have happened or the gaps. All of that was within Mr Vik's own gift. So this is evidence he could have produced to fill all the gaps. He could have produced documents, he could have given a clear explanation in his witness evidence, he could have done that multiple occasions before the committal hearing and in time for the committal hearing and orally. So you have to factor that in. This isn't information that he couldn't have provided.
Well, if you believe the sale agreement, every single document belonging to SHI has been assigned or transferred to VBI, although that's not a point that he seems to have taken.
Which is, according to Mr Vik, a paper company.
It owns a lot of paper then.
The fifth criticism Mr Vik makes of the judge's approach are a number of disparate points about the drafting of the sale agreement, and he says the judge said it was unclear who was responsible for drafting it, and that wasn't fair. But her findings went further than that. She held that on his oral evidence, he was covering up the identity, and that's paragraphs 264, 265, and 267 of her judgment. And I've already addressed you on why that was a legitimate conclusion. So we say in conclusion, the attack on the sale agreement and the judge's findings is hopeless. And can I just address you very briefly now on the new evidence, because we say it doesn't change the position. First of all, the Klug memo. That, in fact, confirms that Norwegian law does not recognise a trust. And it's in tab 6 of the unagreed documents bundle. So paragraph 2, first sentence, Norwegian law contains no concept of trust per se. Now it goes on to have the caveats that Mr Matthews now relies on. It's a letter of advice provided by Klug to Travis Smith in 2014, and there is no reasonable explanation for the failure to reduce it before now. Because, as I said, this was what was put before Mr Justice Cook on the application I've shown you when the sale agreement was produced. The bank adduced Norwegian law evidence as referred to here from Weirsham, it's in little 1 on page 1, you can see that, saying that the concept of trust wasn't recognised in Norway, and that called into question the effectiveness of the agreement, and that's recorded in the Klug memo. Mr Vik produced this memo in response, agreeing that there was no trust, and therefore it's immediately obvious, first of all, it was a document not only available to Mr Vik, but that he chose to deploy when it suited him, and it was a document that Mr Justice Cook considered and reached the conclusions he did based on having seen it. There's no doubt that Mr Vik therefore was aware of the document, and Mr Vik didn't choose to adduce it. And we say it's abusive now, pursuant to the guidance given in Hassan, a paragraph at Authorities Tab 52, to seek to adduce this material now. And what he says, and this is what Mr Matthews said yesterday at page 21 to 23 of the transcript, he said there was no evidence before Moulder J below that Norwegian law did not recognise a trust, and that's why he didn't adduce it. But that's obviously hopeless, because Mr Justice Cook made admissible findings on the point, and they're admissible under the principles in Bailey and Bailey, and it's been conceded by Mr Matthews that those are applicable principles. My Lord Justice Nugee referred to statute rendering them admissible, and he was right. Section 4.2 of the Civil Evidence Act 1972 provides that decisions made by the High Court on foreign law are admissible.
And that's in relation to other parties. I mean, once a High Court judge, having heard evidence, has reached a decision on a point of foreign law, it's not binding on other judges, but it certainly can be relied upon.
Exactly. So that's a bad point. It's not a justification. There are 3 other reasons not to admit the memo. First, it carries no real weight because it's not an independent expert report. Second, it in fact supports the judge's limited finding. I've shown you it wasn't a central finding. It agrees that there's no concept of trust in Norwegian law. And thirdly, if it was admitted, it would provide no grounds for allowing the appeal for the reasons set out in paragraph 22 of our written submissions on the topic. And the only point of, if you want to read the Klug memo, the only point of it is to try and justify that the sale agreement is effective, even though there is no concept of trust. That was his purpose. The second evidence that sought to be adduced is the Zaroff email, which is in the evidence bundle. So this is the 3rd application made by Mr Vik, and it's at tab 4. And we've addressed this in our written submissions on the latest application, which is in tab 2 of this bundle at paragraphs 13 to 15. Again, no reasonable explanation for the failure to admit it below. The Zaroff email was sent by Mr Vik's US attorneys, who've been advising SHI in US proceedings relating to SHI's dealings with Deutsche Bank since at least 2009. And for many years, and we think since at least 2014, they have also been advising Mr Vik personally in connection with US proceedings brought by the bank in which the bank alleges Mr Vik stripped SHI of its assets. So Mr Vik was plainly aware that Zaroff might have relevant emails, and amongst other things, this email was actually copied to Mr Vik, who purportedly carried out searches for documents relating to Devon Park in response to the Part 71 order, and also there was a further search in October 2019, he says. So in those circumstances, there's no justification for why Mr Vik didn't obtain this email sooner. And his explanation doesn't stack up. He says he forgot about it and didn't recall obtaining advice on the AAA, and that Mr Clark was also unaware of it. Now, the second point is the email affords no grounds for allowing the appeal in any event. Taken at face value, the email suggests only that Zaroff was aware of the possible existence of the alleged sale agreement in July 2014, when it was produced, around the same time it was produced in 2014 and nearly 2 years after the as-of date. So it doesn't actually answer the judge's finding that the late disclosure of the sale agreement to the bank in 2014 was suspicious. That's in 211 of the judgment. And it certainly doesn't suggest, as my learned friend asserted yesterday, that there's no doubt the sale agreement was in existence at the time of the AAA. If anything, it just supports the bank's case that the agreement was not drawn to Zaroff's attention prior to 2014.
It must have been in existence at the time of the AAA, because the AAA post-dates the date when it was disclosed in the cost proceedings.
Yes, my lady, but it doesn't, I think, of itself support it beyond that.
No.
And I think that's what it's been relied upon for.
Well, it shows that Mr. Zaroff was aware of something called the VBI-SHI sale agreement in July, which is before the AAA.
I accept that.
Yes.
But what I can show you at the bottom, I don't know if you've looked at paragraph 30, page 35, so the email of the 20th of July, please find attached the assignment agreement drafted by Morgan Lewis for your review. So what you can see here is Mr. Vik asking for advice on the AAA.
Yes.
Here, which supports the judge's rejection of the evidence at the committal hearing that he was not involved in agreeing or aware of the terms of the AAA. So that's pages 272, paragraphs 272 to 277. The second point is we don't know what advice was given by Zaroff. And the third point is, you see, in light of the VBI-SHI sale agreement, is referred to in July 2014. But of course, we know that, as my lady said, we know that it had been disclosed by then, because it was disclosed in April 2014. So all we can see here is nothing more than Zaroff being aware of it after it's been disclosed to the bank, not that they knew it existed in 2012. And secondly, it actually corroborates one of the judge's findings that Mr. Vik was lying because he's seeking advice on the assignment agreement from his own lawyers who are advising him personally.
But what is very strange is, and we may never get to the bottom of it, is why, if the lawyers see it when they're advising on the assignment agreement, they don't pick up the fact that the warranty is completely inconsistent with it.
Well, for all we know, they did. We don't.
Yes, that's the point. That, yeah.
Um,
All right. There's no evidence as to what they did about it, if anything.
Well,
What is your position on this document, Mr. Delaney? Because you can only make the submission that it corroborates the judge's finding that he was lying if it becomes evidence.
well, my lord, I don't need this document.
Are you opposing?
So I'm asking, yes, exactly.
Can I take instruction? Well, my lord, I think we stick with our guns. We oppose it because it is a document that has got no reasonable explanation and has no weight. If you do admit it, it won't actually assist on the judge's conclusions, we say, undermining the judge's conclusions at all, and if anything, it would only support them.
And therefore it doesn't meet the legal test for
That's right.
admissibility.
That's right. So I have to be, I think, intellectually consistent.
No, you're
My
entitled to stand on your stand on your objection, which you've now made clear that you do.
I do.
It's just that since you were making, as it were, positive points from your point of view.
I'm simply saying if you do admit it,
Yes, all right.
there is
I
a
think
positive
that's
point,
I
but
think
I
that's
don't
clear
think
now.
you should admit it, and I don't need the positive point. The judge had more than enough material. And what I would also make the point is Mr. Zaroff hasn't given any evidence explaining why the email was not produced below or what his understanding was of the sale agreement or the circumstances. And he could have done. I appreciate that it might be said, well, it gives rise to privilege issues, but so does the disclosure of this document.
Mm-hmm.
The third piece of evidence is the Blanco affirmation, and Mr. Vik has sought to reduce this in support of the sale agreement as well, and this is in the evidence bundle 2 at tab 5. Similarly, no reasonable explanation has been produced for the failure to produce it below. Mr Blanco's role was directly an issue at the committal application, since he had purportedly signed the sale agreement and, according to Mr Vik, gave Mr Vik all instructions on behalf of VBI to transfer the Devon Park interest to Universal. And that's borne out by paragraph 270 of the judgment, 352, 371, and we also deal with this in Annex 2 to our written submissions on this point. Now, despite being on notice, Mr Vik's explanation is not credible. He says the relevance of the document was not appreciated, and again, it only came to Mr Vik's attention recently following the inquiries of Zaroff. And the suggestion made by my learned friend is because Mr Vik deals with lots of other matters, he might have missed it, is wholly implausible. That's day 2, page 42. If anything, all of this just shows how appalling Mr Vik's disclosure has been. The second point is, again, it affords no grounds for allowing the appeal. In the affirmation, Mr Blanco does not specifically confirm that the sale agreement is a bona fide agreement. The affirmation is concerned with a different issue, which is jurisdictional matters relating to the sale agreement. And Mr Matthews confirmed yesterday that the challenge succeeded. That was at day 2, page 43. So it's clear there were no final determinations in relation to the affidavit. Crucially, Mr Blanco does not say when the sale agreement was reportedly entered into or why. So on its face, it provides no credible support for Mr Vik's case. It doesn't establish that the agreement was made in 2012 or reflected a bona fide transaction. And Mr Vik again hasn't called Mr Blanco to give evidence, and the credibility of his evidence wasn't and can't be tested. And the affirmation doesn't counter the judge's finding at 271 that the absence of disclosed correspondence with Mr Blanco is surprising. So the document can't be given any evidential weight at all. The fourth piece of new evidence, and I think your lordships obviously have on board the number of different pieces of evidence Mr Vik is now put in, is the VBI note. And we address this in paragraphs 24 to 34 of our written submissions on the new evidence application. And it can be found at tab 5 of the unagreed documents bundle. The document was produced by Mr Johansson in 2014 in response to the bank's application for costs and the non-party cost order against Mr Vik. So it's the same time as the sale agreement, and it was one of the two documents Mr Justice Cook looked at, and then the Court of Appeal had a decision following from. And again, it was produced out of the blue without any supporting contemporaneous documents, and it was exhibited to Mr Johansson's 6th witness statement. It's said to be a Norwegian promissory note documenting purported loans from VBI to SHI, and it was rejected by Mr Justice Cook in a non-party cost judgment as changing the position at all. So it is surprising, given all that background, that Mr Vik deliberately chose not to rely on this before Mrs Justice Moulder. So we say if he had wanted to, he knew that he had this document, he deliberately chose to, and we say the reason he chose not to do so is because it lacked credibility and had been rejected by Mr Justice Cook. And just so you know, when the bank sought to add Mr Johansson's exhibit, the witness statement, to the bundle, Mr Vik refused permission. So he refused to allow this to go in, and now he's seeking to reduce it. So in those circumstances, we say the application to reduce the note must fail. In any case, it lacks credibility or any weight. It's self-serving. It's unsupported by contemporaneous documents. It's got no credibility for the reasons Mr Justice Cook has already found. No proper reason has been given for the failure to adduce it below, but we know it must have been a deliberate decision. And it seems to be his case that he didn't realise it needed to be adduced because the judge held that the VBI SHI transfers could be loans rather than gifts. Now, that's hopeless. If Mr Vik felt that it bolstered the bona fides of the sale agreement, he could have put it in. So that's not a good explanation. And finally, we say it wouldn't change the case because it doesn't support Mr Vik's case that 5 transfers made by VBI to SHI, said to be payments under the sale agreement, were payments rather than loans. So his case is there were payments made that aren't reflected in this document, which records loans, therefore they must have been payments under the sale agreement.
Hang on, it can't be if it's a pro note. If it's genuinely a pro note, then any money that is referred to as having been transferred over in a pro note would be immediately repayable on demand. That's what a promissory note does.
Yes.
So if it's genuinely a pro note, it couldn't be a sale.
No, what
money.
Mr Vik's case is, which I don't think has been clearly articulated by anybody, is this pro note created by Mr Johansson and produced in 2014 doesn't include transfers.
Oh, I see.
It's an acknowledgement of what is owed as at September 23rd.
And it doesn't include the 300,000.
And because it doesn't include the transfers,
Norwegian crown.
therefore it follows that the transfers were made.
Oh, I see.
So
it's an admissions point.
Yeah.
Okay.
But the fact is,
Yes.
But the fact is, it doesn't tell you anything. There's no evidence that the VBI note is comprehensive, accurate, or legitimate. Its credibility has been roundly rejected.
Yes.
And all the other documents prepared by Mr Johansson, or I say all, many of them, have been regarded either as fabricated or inaccurate. For example, the schedule of assets sold under the sale agreement, which we've looked at, the 2015 document, it's Mr Vik's case that it's inaccurate now, because it shows VBR, it doesn't show VBV holding the IFA interest, it shows SHI. I'll show you that. It's his case it's inaccurate. So this tells you nothing, because you'd have to accept that this document dealt with the position comprehensively, then accept that the other payments could only be explained as payments under the sale agreement. And neither limb works.
Am I right in remembering that this is a document which is acknowledged to be prepared for the purpose of the litigation?
Yes, it is.
Yep.
It is.
And of course, for the purpose
for
of
the
showing...
purpose of the 2014 litigation.
Exactly.
And of course, that was at a time when the explanation about the sale agreement could have been given then, because both documents were produced, and it wasn't. It's only been made now. And now, I say now, on appeal, not below. So, can I just then, I'm very conscious of the time, so I'm sorry to move at a pace, but I did want to show you the other documents from Mr Johansson, because they then put to bed the universal point, which is the final piece in the judge's reasoning.
All right, well, since you've mentioned the time, you are aware that there is a point we're interested in, which you promised us an account of.
And I was going to, I think I have till 3:15 or 3:30.
Yes. All right, as long as you have that in.
I do, and that's why I want to finish this now,
Yes.
and then I've got that point to do with, in the context of where, my lord, it arises, which is the documentary disclosure. That's where it arises, and that's where I will take
Understand that.
So, can I just show you that the final piece of the jigsaw, and it's important to remember that the judge had all of this material looked at in opening, 4 days of cross-examination of Mr Vik, following Mr Matthews' submissions in opening, and then closing. So she had a long time to look at it, because I think she may have seen these documents 3 times, and had the benefit of Mr Vik's evidence to where there were questions, or to give him the benefit of the doubt. What these documents showed, and again not disclosed by Mr Vik, were that Mr Vik continued to have an economic interest in the Devon Park interest after it was transferred to Universal, up to at least the end of 2015. And this falsified both the suggestions made about the sale agreement and all the other points, but also the evidence that Mr Vik had, quote, no connection to Universal. And the documents told a compelling story on this point, and they were dealt very well by the judge in her judgments in paragraphs 219 to 244 and 286 to 315. And they led to, as the judge put it, the irresistible inference that Mr Vik continued to retain an economic interest in the Devon Park interest after its transfer to Universal. And that's 336 of the judgment. The documents demonstrate 3 points, all of which are fatal to Mr Vik's case. First, that he had the economic interest in the asset, certainly up to the end of the document run. So can we look at, please, supplemental volume 3. And it's tab 32, please, page 879. And can I just make the point that there are a lot of documents and the judge went through all of them. I can only show you the highlights. And what you can see here is in November 2014, you see Devon Park sent a capital call notice to Mr Vik, addressed to him personally, copied to Mr Johansson, which I think we see on the covering email, which is at page 878. And when Mr Johansson responds to the email, he doesn't suggest that notices should not be sent to Mr Vik anymore because Universal was now the owner. You then look at page 262 in tab 32 of the core supplemental bundle. I'm sorry to keep moving between the two bundles. The documents appear to have been split. And what this shows is that in March and April 2015, Mr Cantasaria, the managing partner of Devon Park, sends to Mr Vik his annual report, and Mr Vik exchanges emails with Mr Cantasaria inquiring about Devon Park's future strategic plans. And the judge recorded this document in paragraph 223 of her judgment, the previous one in 220. At page 260 of the same clip, Mr Vik also asked about a forthcoming distribution amount. And the judge pointed out that Mr Vik's interest in Devon Park's future strategic plans contradicted his evidence that he ignored Devon Park's emails completely. And that's quoted at 221 to 223 of her judgment. Is also contradicted by his later evidence that he didn't know Mr Cantasaria well enough to drop him a line. And that's referred to at 289 of the judge's judgment. And the fact that Devon Park shared its annual report and responded to Mr Vik's inquiry with confidential and arguably price-sensitive information strongly suggests that Mr Vik retained an interest in the asset. If we could then go to page 264, please, you'll see that on the 11th of May 2015, Devon Park sent Mr Vik a notification of a capital distribution of 2.5 million addressed Dear Alexander. His evidence, quoted in the judge's judgment at 229, was that this was a mistake on Devon Park's part. But as the judge observed at 291, neither he nor Mr Johansson nor Miss Felix, the lawyer dealing with the asset on behalf of Universal, replied to Devon Park to say it was a mistake. And then in December 2015, so months later, Devon Park sends to Mr Vik a 44 million capital distribution notice, and that's in supplemental volume 3, tab 32, page 951. Page to 952. And Mr Vik had no credible explanation for this email either, as the judge recorded in 239 and 292 of her judgment. And again, no evidence that he or Mr Johansson suggested to Devon Park that this was an error. And even as late as March 2016, Devon Park sends its annual report to Mr Vik. That's at page 953 of this clip. So Mr Vik's case that there's no connection with Universal and he doesn't know anything about the company is belied by this. It looks like he retained an economic interest in the assets, certainly up until at least the end of 2015. Now, the documents secondly show that Devon Park, Mr Johansson and Universal's lawyer had extensive communications from 2014 to 2016, which were consistent only with Mr Vik or SHI retaining an economic interest in the asset. And the judge recorded in her judgment at 312 to 314, the original 2014 negotiations to transfer the asset from SHI to Universal were conducted by Mr Johansson with Devon Park, with no evidence of involvement of anyone else. So Mr Johansson was working for both sides of the transaction, consistent with Universal not being a real third party to Mr Vik. Now, Mr Vik had no credible explanation for that, and although the transfer had only been under discussion, since January 2014, Universal was only identified as the recipient in July. So Mr Vik had been discussing a transfer to an entity, but it took months for the entity to be named. And I won't show you all the documents, but you can see Devon Park get frustrated, as the judge records, because they don't understand why they're not getting the details of the asset. And one email even asks, and this is at tab 32 of the bundle you should have open, page 943. One email even asks whether the buyer is affiliated with Universal or Sebastian or is a true third party. And this is talking about a further offer. But the issue is the distinction seems to be Universal or Sebastian in one bucket and a true third party in the other. Now, Devon Park exchanged emails with Miss Felix and Mr Johansson in connection with draft US tax filings. And Universal's accountants provided details to Devon Park showing Universal's address as SHI's office in Monte Carlo. And you see that at page 900 of the clip that you should have open. So it's 900 to 901, and you can see on 901 partner's name and address, city, Devon Park is listed, and then Universal, and that address of Avenue de Grande Bretagne is SHI's address. And if we go over to 907, you can see that. Mr Vik claimed it was a mistake, but couldn't explain why Mr Johansson, who was copied in, which you see at 899, did not correct the error. The judge recorded that at 227. And again, the judge recorded that Miss Felix didn't correct Devon Park from its assumption that Universal and SHI were associated. And then in December 2015, Devon Park pressed for an explanation of who the proposed buyer was and what relationship it had to SHI stroke Universal. And the document is at 947. And when it failed to get a satisfactory answer, it sent another email demanding to know, and we see this at page 945, who owns and controls it, its tax status and the relationship to Alex Vick and Sebastian. The third point is that the documents showed that Mr Johansson continued to manage the Devon Park interest on Mr Vick and SHI's behalf until at least early 2016. And you can see that from the email at 958. And this is the famous good manager management of time evidence. So what we see is that the documents show that there was a clear connection to Universal, and Mr Johansson is in it up to his neck and acting on behalf of SHI Mr Vik, and this is not explicable on Mr Vik's evidence that he had no connection to Universal, given that Mr Johansson works for SHI Mr Vik, and we've had no real explanation of who Universal is and is connected to. And the judge's findings are challenged by Mr Vik in connection to Universal in his skeleton at 151 to 177. They were not really addressed in oral submissions, we suggest, because the evidence on this is overwhelming. And we have addressed them in our skeleton. It's said mainly, I think, that the judge didn't precisely identify the exact nature of Mr Vik's connection to Universal. And this complaint has been made over and over again, including before Mrs Justice Cockerell. And the fact is that the judge has made findings that were legitimate, that Mr Vik was connected to Universal because he continued to have a direct or indirect economic interest post-transfer of the Devon Park interest to Universal. That was particularised in DB's schedule. And it was not possible nor necessary for the judge to go further because it's not clear how the judge could have identified the precise nature because Mr Vik won't tell us. And that's precisely the point that Mrs Justice Cockerell made, that it would make a mockery of justice if the person who's deceiving you, who has the information, can say, aha, you don't know, when the only way you could know is if they told the truth. And the second point that Mr Vik seems to try and argue is that his economic interest in Devon Park was not a connection to Universal. And we don't understand that point, and Mr Matthews appeared to concede yesterday at page 53 of the transcript that Mr Vik holding an economic interest in the Devon Park interest would be a true and arguable basis for a connection to Universal. And that was I'm sorry, it wasn't yesterday, it was in the transcript of closing submissions below, day 10, which is in Core Supplemental Bundle tab 8, page 65, cited in the judge's judgment at 338. Yesterday, in fact, Mr Matthews said something different, but it's not open to him to say that, and the reference to what he said yesterday is dated page 53. And finally, Mr Vik then spends the rest of his skeleton trying to re-argue the case below, and that's exactly what he's not entitled to do. And as I say, I do appreciate that taking you through the evidence, by definition, almost invites you to form your own impression of it. But I'm doing that to show you why the judge had a legitimate basis for her findings. It may be, and I don't think she was wrong in her findings in any way, but it may be that each of you might think, well, actually, that piece of evidence by itself could have been interpreted differently, or if I'd been looking at it, I would have asked this question of Mr Vik. But the judge went through very carefully all the documents. She heard Mr Vik. She reached the decision she did in the round, as she said, which is exactly what she is supposed to have done. And with respect, this court doesn't have all of that benefit or indeed the time that the judge had. And even if this court thinks that individual things the judge may have done may not have been the decisions made by any one of you, the question is not that question as a matter of law. It's whether she was entitled reasonably. And the test is very high that Mr Matthews has to overcome. And in reply, maybe he'll address it, but he didn't really engage with that test and how his submissions really fit into it. So, my lord, I've finished on this topic more or less. I'm going to be very brief after lunch on the IFA shares because they weren't addressed in great length by my learned friend and everything's set out in writing. And I'm going to do that so I can come to the new point and give plenty of time for that.
Very well. All right, we'll adjourn now till 2 o'clock.
What's your name?